Morning. Thank you.
SJC-11011, Costa, Brait Corporation.
Good morning.
Good morning, Your Honors. My name is Stephen Schultz, and I represent the defendant, Brait Builders Corporation, in this case. As I only have 7.5 minutes of argument, as I'm splitting argument with the co-counsel, let me just cut to the chase. This case involves a $900,000 contract which was not completed. By the plaintiff's own accounting, only 72% of the work was completed. They put in requisitions for only $649,000. They were paid $533,000. That leaves a retainage of $116,000. In addition, they put in for an extra work order of $36,000. In addition, they claim lost profits. There was $250,000 left on the contract. They claimed 10% profit. That's $25,000. The point of all these numbers is that adds up to $175,000. General damages in this case were found to be $199,000. That is all the damages that should have been found in this case. We obviously don't add up to the $199,000. There's a $24,000 check which was bounced, and maybe that's how the $199,000 came. I don't know. We wouldn't be before this court if just over the difference of the $199,000, $175,000. We're here for one reason. The judgment isn't $199,000. The judgment isn't $175,000. The judgment is $800,000.
There was evidence of other kinds of damages, and including a loss of business, loss of home, consequentials, and the jury did award a fairly hefty consequential damages amount in addition to the 93A.
Well, I would say as a matter of law, there's really not a shred of evidence of consequential damages. Consequential damages are defined as damages. First of all, they have to be proven to a reasonable certainty, as you know. And second of all, they're defined as damages which are the natural and probable consequence of determination which would have been in the contemplation of the parties at the time the contract was made. In this particular case, the damages you're just talking about, the plaintiff went out of business 3 years after the termination, according to him, because construction work was low in Massachusetts, so I had to leave to Florida. That simply can't have been in the contemplation of the parties 3 years earlier. The loss of the home was 3 years later on a mortgage which wasn't taken out to 2 years after the termination, which was then foreclosed upon. I would suggest that there really, as a matter of law, is not a shred of evidence of consequential damages in this case, and that simply cannot be part of the damages that there are in this case. In addition, there are
I thought part of the evidence about the termination that might have been sufficient evidence to support the 93A was the fact that because of a long working relationship, your client knew that the subcontractor had given up all other business in order to participate in this construction project. And then when he started taking a retainage of 20% instead of 5%, he was forced to take out a lot of loans. I just don't know how you would argue that that might not be evidence that would support those other claims.
If the plaintiff had put in any evidence about with a dollar figure on loss of business that he gave up, all he said was he gave up the other business he had, because this was such a big job. He did residential jobs. He gave up his other business, which he said he gave up for nothing. They were residential type clients who had needed sewer systems in their yards. It's not the kind of case where you have a regular repeat type of client that you then lose because for 6 months you go on. These were one shot in. You're in for a week, you're out for a week, you build the septic system. This wasn't a loss of business which would go on to the future, which you could then say is a type of consequential damages. I firmly believe that while typically appellate courts aren't out there looking at the evidence as you're talking about, it's just not even close in this case that there's any evidence which can stand up legally as consequential damages.
Now, help me with this. I had thought the contract said that your client could terminate at will.
That's correct.
So the basis for a breach of contract, and that same provision, I thought, said if you were to terminate at will, they get essentially quantum merit damages.
That's also correct.
How do you, as a matter of law, how do you get consequential damages when the measure is quantum merit?
You don't.
Did you argue that in a motion for directed verdict or anything?
That they can't get consequential damages? Yeah. It was argued in a motion for a new trial.
Are you arguing that on appeal?
Yes.
Specifically with respect to directed verdict?
The directed verdict, there was an argument of the can't get consequential damages on the directed verdict. It was based on a contract clause. In the motion for a new trial, he mentioned as well that there was no evidence of consequential damages.
You make a 93A claim also on appeal that wasn't raised below. Are you going to address the 93A?
On the 93A, it certainly was raised below. The 93A, there was raised that it was duplicative damages. That was raised below, and it's raised on appeal.
I guess I mean that you didn't challenge the finding, the instructions.
I don't think it was, again, I think that on the duplicative damages issue, I think the obligation, there was nothing wrong with the, there was a lack of instruction that the plaintiff should have been challenging, that there was no instruction saying that you cannot get duplicative damages. I think if you look at the appellate...
Didn't the instructions, though, say that it would be related specifically to what was unfair and deceptive?
The instructions as they relate to damages on 93A, to the best of my memory, were two sentences, one of which, the only one I can remember, was, please remember that money means money. And I think the other sentence...
They quoted something that was pretty specific about language relating. It may not have said anything about duplicative damages, I don't remember, but it was zeroed in on 93A.
There were two paragraphs where he discussed, now let's go to 93A damages, and he then essentially said, remember on 93A damages that money means money. And that was the instructions regarding 93A damages. There were pages of instructions on the breach of contract damages.
What was the theory of 93A damages in light of the contract provision that allowed termination at will, essentially?
In my opinion, there was no theory, but again, I'm the defendant.
What was the is that Article 9 of the contract, the termination at will?
Yes, it is.
There's a quote in the Costa brief that, in fact, the CEO of your client's company, of your client, said, no, we're not going under Article 9.
That he did state that at trial.
He did?
He did.
So that, doesn't that mean that particular, it isn't termination at will? Isn't what you did?
It means that a lay witness doesn't know what to say on a legal question, is all it says. He was asked, is this a contract provision?
Jury could find otherwise, couldn't it?
The court might find otherwise, but obviously that's what he did. And at trial, did he give that specific answer? He did. I can't tell you he didn't.
Mr. Schultz, your time is up.
I see that.
Good morning, Your Honors. Danielle Long for the Surety, Arch Insurance Company. First and foremost, I would just like to bring to the Court's attention the way the issue that was taken on direct appellate review was whether the rights and remedies of the public payment bond statute 14929 can be waived. What we actually have here, and given the particular circumstances of the case in front of us, is a condition precedent. It's not a strict waiver. The relevant terms of the contract are found in Article 7, and the terms are as follows. If the subcontractor, Mr. Costa, could not get his own payment and performance bonds, he agreed to give up his right to collect under the GC's public payment bond under 149 Section 29. And what we have here is a private agreement between two parties to a commercial transaction. The agreement between Brait and Mr. Costa only affects Brait and Costa's rights.
But if it's a public policy, it doesn't matter that it's a private contract, right?
Agreed. What is important is whether it's a condition precedent or a waiver. If it frustrates the public policy, it's not going to be enforced. So, and again, it's sort of wordplay, but I think the terms of the contract, it is important that it's viewed as a condition. But I think what the issue is whether or not in these particular circumstances, enforcement of this condition and or waiver, would that frustrate the public policy of this payment bond statute?
And what is the public policy? To ensure that subcontractors and their employees get paid?
Yes, and it would be our argument that the policy of the public payment bond statute is to protect the individual rights of the laborers and the material men, because in public, on public projects, they don't have the ability, they don't have the mechanics lien. You can't put a lien on a public project. So they want to put them in the same footing as private contractors are on private jobs. But obviously, there is a public policy nature to it, which would be to put them on the same footing. But regardless of that, what needs to be looked at here is whether this agreement between Brait and Costa, if enforced, would frustrate the public policy of the payment bond statute.
Could I just ask you, when you said that's the public policy, and I just don't know how this works, but if material men and labor work for Costa, mightn't they not get paid if Costa can't go after this bond?
No, they may not, because under the Peters case, the 1979 case, you don't need direct privity to collect under the public payment bond statute. And that's why even if Mr. Costa gave up his right to collect under this bond, the subs or the subcontractors can jump ahead and certainly make a claim against the bond. This agreement in Article 7 of the contract only affects Mr. Costa's ability to collect under the payment bond and no one else's.
Is Brait out of business?
I do not believe so. No, and again, it's.
I'm confused here. Let's say Mr. Costa has employees. You're saying the employees can then sue the surety bond company directly?
Mr. Costa's employees, yes, they would be able to do. Subs of subs. Well, it depends if the employees are actually working for Mr. Costa, no. I mean, sometimes it depends you get into the logistics of who's actually employing the employees.
What about the suppliers?
Yes.
So I'm a lumber company. I sold $10,000. I haven't gotten paid. I would go after the surety bond, and it wouldn't matter what Costa agreed.
Exactly. And that, I think, that remedy is consistent with this Peters case, which it was in front of this court whether or not you needed privity to collect under the payment bond. That's why in this particular circumstance, it's purely a private agreement between Costa and Brait.
Well, if it only affected Costa and Brait and not any of the employees of Costa, well, maybe that would be a different case. But does it affect the employees of Costa?
If the direct employees of if Mr. Costa can't pay his direct employees and he looks to the bond, yes, it would affect Mr. Costa's any workers hired directly by Mr. Costa. What it would not affect is Mr. Costa's subcontractors, the subs, so to speak. But it's as far as completion of the project, it was a school here. By Costa agreeing to this, it's not going to halt the project.
So why couldn't this agreement sort of trickle down? Why couldn't Brait require each of the subcontractors and the subcontractors to agree if you say it's okay? So therefore, the surety bond company could escape all liability.
Right, well, that was certainly the intent of Article 7, because under under Peters, it's allowed, it's not against public policy for the GC to require the subcontractors to be bonded and for any subs of subs to be bonded. By getting obviously there's an extreme amount of risk associated with hiring an unbonded subcontractor. So through this...
Clarify there's some confusion in my mind about, I understand that there's a contract provision and there's also some maybe evidentiary dispute or inconsistent evidence about what Brait knew regarding the ability of the subcontractor to obtain the bond. As I understand it, he couldn't do it because he was so small, and they knew that. So, but what's really happening then in a situation like this is you go to a small sub, they can't get what you're telling them you have to get, and then you say, well, you can't get it and you can't sue on mine.
Well, I think the record is a little unclear as to the exact timing of when the conversation took place between Brait and Costa.
It was probably before he increased the retainage to 20%, which is because that's why you did it, right?
It's my understanding, yes. But the contract was entered into the beginning of summer, and I believe in July or so, the record testimony from the trial states that Mr. Costa approached Brait and said, I can only get a bond for $200,000. But by then, the agreement was already entered into. Mr. Costa may be small, but he was a very experienced businessman. He'd been in the construction industry for 30 years. He'd had his own company since 2000. He was very well aware of the payment bond statute, unlike some of these other cases that we've briefed, the Venus Drywall case, for example, where the exact issue wasn't obviously whether or not they could waive this public payment bond requirement. But in those situations, in those cases that are in our brief, the waiver comes after the fact. So the parties have already entered into the original contract, and then the GC says to the subcontractor, you tell your subs I'm not going to pay them unless they sign this waiver. You know, what we have here is Costa knew what he was entering into. I mean, there's no ambiguity issue here with the terms of Article 7. They had to somehow afford for the additional risk of working with this subcontractor, experienced but small, that was unable to get a bond, because now they're going to be liable for everyone downstream. The project's still going to get done. Brait also had to get a performance bond. They have a payment and performance bond as required. This is not an issue where there wasn't a payment bond at all. It's there. Just Mr. Costa agreed that he would not, he would not have the right to take advantage to collect under it because he couldn't obtain his own bond.
Now help me. Let's assume with regard to Brait, Brait has a surety bond, of course.
Yes.
And let's assume Brait goes out of business. Can the employees of Brait seek to collect against the surety bond?
If Article 7's enforced, the direct employees of Brait would not be able to, no.
Could they go after the retainage?
Not of Costa, of Brait.
Of Costa, I'm sorry.
No, a Brait. I'm saying basically, would a surety bond provide any insurance for employees in any event?
Of Brait, I believe so, yes.
They would?
I believe so, yes.
Even
not
though,
of Costa.
Even though
because
the employee could probably not file a mechanics lien?
The employee probably could file a lien on the funds, but a mechanics lien, no, you cannot file a mechanics lien on a public project. There's liens on funds, which, the employee would have various other remedies to pursue against Brait if they fell out of line, but a pure, statutory mechanics lien, that's not going to be available on a public project. But other types of liens are.
So what kind of a lien are you talking about? Is it like a trustee process?
Yes. I would think that Brait's employees would have that type of lien available to them to pursue Brait.
But
that's not.
It would only apply to the retainage.
Yes.
Which is down to 5%.
No, we're talking about Brait, not Costa's employees, Brait's employees.
Well, I guess the question in general is,
what remedies would they have?
May an employee of a company with a surety bond go after the surety for unpaid wages?
I believe so, yes. The waiver here in Article 7 would not apply to that. It's not applicable. It's not the issue that we have here. It's strictly Costa v. Brait.
So what happens to Costa's employees? There's no performance bond, do they have any kind of a remedy if Costa doesn't pay them?
If they would not, because if they're strict employees of Costa, they would not have the remedy. They would have a remedy against Brait, but they would not have the remedy against the surety. They could go after Brait, absolutely.
You can't go after the surety because of this contract?
Right, because if an employee of Costa is Costa, it was just Mr. Costa. Again, looking at the particular circumstances of this case, because that's what you do with, for example, a 93A waiver in the Canal case we talked about. You look at the particular circumstances of this case. This case, we just have Mr. Costa. Okay, he agreed to waive his rights to collect under the payment bond. Okay, the issue is whether or not that condition and or waiver would be enforceable. And it's our position that it would, because again, it's just affecting Mr. Costa and Brait. It's not affecting any of the subcontractors that Costa retained to complete this project. And again, as far as the concerns of the school getting completed, Brait does have a performance bond, so which flows up. I mean, the work has to get done. You know, if Mr. Brait, or if the GC walks off, you know, the project, or Costa's not doing his work, I mean, a lot of times the surety even takes over the project and finances the project. I mean, the work will get done. So as far as by allowing a waiver in this particular circumstance, it's not going to have a grave effect on the completion of the project. I mean, I think what is very
Ms. Long, your time is up.
Okay, thank you.
You're welcome.
Good morning, and may it please the court. My name is Eric Kupperstein, and I represent John Costa. Let me first highlight a couple of things that may not jump out at you in the briefs. The first is that there were competing jury instructions and verdict slips in this case. These were cross 93A breach of contract cases. So any objection there would have been to the jury instructions or to the verdict slip would have been incumbent, I would presume, on both parties thinking that they were going to prevail at trial. The second thing is there was a long charge conference. This wasn't a situation where the jury instructions were gone over lightly. The fact of the matter is, at the end of the day, the judge pretty much gave the model instructions, both on breach of contract and on 93A, and that's set forth in the charge conference. The next thing that is...
And what did the judge instruct with respect to 93A? You've got to tie, basically, you've got to tie the damages to the unfair or deceptive act and practice, but didn't say anything about no duplicative damages. Is that right?
That is not right. He said the first part of what you said, that he specifically gave them the instructions. The jury verdict form sets forth that, so it's different than Kirksey in that sense. What the judge did was he gave out a jury verdict form to every juror prior to the closing arguments. And this is probably not highlighted in the briefs, and that's my error, and I apologize if it doesn't jump out. But it's at the appendix at 3615. And what the judge did after he gave those out, he went through that verdict slip with the jurors, and he specifically stated, he didn't use the word duplicate, he used the word overlapping. What he specifically says is that you'll notice there are several areas in which you can consider awarding damages. There must not be any overlapping of the award of damages. Each area or category is entitled to its own separate distinction. The clerk, if you do award damages in more than one area, will do the addition. You don't have to do that. There's no need for that. But if you decide, for example, to award damages under 4A, that was the breach of contract, those damages must be consistent with the law that applies to so-called general damages and a breach of contract and should not reflect, for example, a Chapter 93A award, because that is in a separate category, question 7. And then he went through the questions.
Could you give me that, is that a transcript?
It is from the tree, yes. It's at the appendix 3615. And he went over that with, I was the trial counsel, he went over with that in the jury charge.
Okay.
So I don't know what more this judge could have done. I mean, he gave the model instructions. He did everything he was supposed to do. He warned them against duplicating damages, and he specifically said the elements necessary to find. Now,
and what was the theory of unfair or deceptive practices?
Well, it depends on who you ask, I think. And
which you were trial counsel for the plaintiff, right?
I was trial counsel for the plaintiff.
So what was the plaintiff's theory?
It was our theory that the breach of contract was the withholding of the retainage. It was our theory that the unfair and deceptive acts and practices was how Brait treated this subcontractor. And there was volumes of evidence concerning how they refused to tarp the building, how there was 6 inches of frost inside the building. My guy's the site contractor. They were pulling the plugs on his pumps to dewater the trenches so he could dig for the electricians, et cetera. There was a multitude of acts that they did, we allege, on a nefarious scheme to bleed him out of everything they could to get the work done. And you're right, he did about 70% of the work under those conditions. And that doesn't include extra work orders, which the judge didn't give us. He only gave us 30-something thousand, I think it was, over a couple hundred that we're asking for. And here's the thing. Once they get rid of Mr. Costa, which is what they did, when he said to them, he wrote them a letter and he said, look, I can't work under these conditions. I can't dig with the earth people won't let me dig while it's frozen. I've got to leave I'll come right back as soon as it's. They terminated him, claimed he abandoned the project, sued him within 3 business days for $1 million, and tied up his bank account, ex parte.
What was your theory as to why they would do that?
Because once they get him out of the way, and he's done all the real hard work, they get the profit. They get the extra work orders. They get the profit on that. They get to charge 10% for that and 10% for overhead, which they already have in place. So they get to bleed him dry. Now they get to take over the work, pocket the profit, which, according to their counterclaim, was $750,000 to finish the work. So this wasn't, there was only a couple $100,000.
This makes some sense. Did you argue this?
Absolutely.
And he only gets quantum merit. Costa only gets quantum merit, theoretically.
Well, no, but because if we think the breach of contract was the retainage issue, that's separate than the 93A.
And what I think your position, I take it at trial, was that this was not a termination under Article 9.
Oh, it absolutely was not. And we asked him, I think, 4 or 5 different times, and that's in the record. And
say that, but a termination is a termination. I mean, the contract says we can terminate you for any reason. So why must they say it's under Article 9?
Because they're
allowed to terminate you.
Because they were claiming abandonment.
So what? But they can terminate you according to that provision for any reason. They could do it because it was a bright and shiny day.
But I think the reason why, if you want my opinion, they didn't do that is because if they do, they have to pay him quantum merit. If they terminate him pursuant to Article 9, they then have to pay him for all the work that he did, the fair value for the services rendered. They didn't want to do that. That's money coming out of their pocket. So they said, no, we're not terminating you pursuant to Article 9. We're going to claim you abandoned the job, and therefore we're going to take over, and now we're going to pocket the profit. We're going to pocket the extra work that's going to, all these public jobs have tons of extra work.
But quantum merit only means the work that you've already done, not the work that you would be.
Understood, but they withheld from him not only the retainage, but they also withheld from him certain extra work orders, and the jury could have found that based upon the value of his services, where he brought that project to, they could have given him quantum merit damages, which would have exceeded any out-of-pocket, for example, that he had for costs and for bringing the project to the point where he did.
Did they send him a termination notice?
They did send him a termination notice.
Using that word?
Using
the word that the contract is terminated.
I don't know if I have that. Let me see. I will take a very quick look. Let's see if I have it. I do not have that. I do not believe that they used those words or used Article 9 or anything to that effect. And the fact of the matter is, within 3 business days of Mr. Costa informing him, see, they didn't send him a termination letter per se. He informed them that I can't work under these conditions.
So there was not an issue at trial that termination versus abandonment, that this whole thing is a pretext. That was not an issue at trial. They were proceeding under the clear theory of abandonment.
Yes.
At trial.
At trial, absolutely. And that's why we asked them. Because we went in thinking maybe differently, as Judge Gantz pointed out. If it's a termination, it's a termination. But we went in thinking that might be what their theory is, but they came straight out and said, no, it's abandonment. So
that was the basis of the counterclaim, is that right?
And that was the basis of their counterclaim. And they charged, again, how they knew 3 days after the fact that it was going to cost $1 million to finish. But even in their closing, they claimed $660,000. So if you start to add these damages up, what you come up with is clearly more than $500,000, which is what the jury awarded. The jury awarded $500,000 broken out into 3 separate categories: general damages, consequential damages, and the 93A. I mean, if you just start adding some of this up, you have the retainage, which is $125,000. And this is, again, not even having to get into his loss of business of other jobs, which we, without objection, agreed to. Tax returns were put in. Balance sheets were put in. His testimony, he was a small contractor. He did business as Costa and Son. It was him and his son and a few workers. He met Brait Builders by going to the prior job at Silver Lake School, where they had gotten rid of a prior contractor, and he stepped in.
What was your theory of wrongful termination of a contract? Or wasn't that your
It
theory?
was constructive termination.
Yeah, he was constructively discharged because they frustrated his ability to perform the essential functions of his job. Damages. We have $125,000 worth of retainage he never received. We have, if the jury believed the fact that Mr. Costa testified that he had to take out a line of credit because he couldn't afford to run the job, only having an extra 15% of his money withheld. Then you have a non-payment of $66,411.35 on a November requisition. You have non-payment of a December-January requisition of $49,505.15. They stopped the check on him for $24,715.35. They didn't pay him the extra work of $36,022.96. 10%. They believe that the profit was being paid along the way. The profit on these jobs, Mr. Costa didn't, and he testified to that, didn't pocket a penny of profit until he was waiting for the job at the end. So he didn't receive any of his 10% profit on the amount that he completed, which was $62,755.66 would have been his 10% profit. 10% profit on the balance of the contract. It goes on, and I've put it in the brief. So there's much.
Right.
Thank you,
Could
Jeff.
we turn to the bond issue?
Yes.
Just before,
Yep.
I just have a factual question. You can collect. I mean, if the judgment is affirmed, you can collect from Brait, can't you?
Well, I'm not sure we can, Judge, and here's why. We've tried, and it's in the record. It's part of the docket sheet to have some preliminary attachments to secure our judgment.
If they're not out of business, correct?
They're not out of business, but we did our research and we found their jobs that they're working on now, Newton High School, for example. And so we went in and said, look, we want to at least the retainage that's being held from them. We want to have some security. Unfortunately, unlike in the federal court, we don't get a bond as a matter of right, so we asked for that or in lieu of some attachment. And they objected, and under the case of Pettibone versus Toledo, which says you cannot attach future funds of an executory contract. So I don't know if we can collect against Brait, because that's all they do. We've done interrogatories post-judgment. They say we don't have any assets. We don't have anything. All we do is we have these contracts. And oh, by the way, we haven't been able to secure our judgment because it's under that case.
So with respect to the bond, the argument that Arch makes is, look, this is just between the whole purpose of that statute is to protect material men and suppliers downstream, and this is a private contract between you and Brait, and you agreed to it, and tough luck.
Yes, I heard them say that. But
And
the
what do you
fact
say?
the fact of the matter is, this statute uses the directives shall, and it states that under 149.29, the general contractor shall have this bond, and it also states that those working on the public building projects or other type of public projects shall have the right to go against the bond.
I mean, assuming that to be the case, you couldn't have been in this job at all, correct? Because you couldn't get the bond that was necessary.
Not true. What Peters teaches us is that they being Brait Builders, could have refused to work with Mr. Costa, fine, or it could have required some other form of security, or it could have increased or agreed upon some different retainage. It could have done all kinds of things. What it can't do is then say, and then you can't go against our bond. So it doesn't have to work with them, but if it does work with them, it can't preclude him from going against the bond. And I believe it was Justice Cordy who asked, well, what's the public purpose of that? And the public purpose is that it expedites the payments. They were talking about liens you could have or a trustee process. Well, that's if you have to bring a lawsuit and you have to go after assets, et cetera, which, as I've told you, I'm finding out isn't easy to do. But the fact of the matter is it improves the flow of funds on construction jobs, public jobs. It is an unhampered completion of the project so that people don't have to stop and go bring lawsuits in the middle of projects. It fosters competitive bidding, because if for example, there could be a chance that you'd be required to waive your 149.29 bond rights, then you're going to hedge your bets on your competitive bidding. You're going to bid higher to cover those kind of potential losses. It gives security for all laborers on the jobs. I'm not sure that they're right that employees who don't get paid can then go against the bond. That's why in the case of Venus Drywall, where the court said, though in a rescript opinion, though it doesn't involve the 149.29 issue, we're not sure we'd ever even allow a waiver of those rights under any circumstances. And it affects the public. This isn't. They made a correlation in their briefs to condominium rights and things of that nature. What I believe the line of cases say is that it's only if it's a purely private right, that we will allow a waiver of a mechanics lien statute, for example. And even in that statute, it goes through and only gives certain circumstances. The legislature didn't have to do that under 149.29 because it says shall. There are no circumstances where you could waive that right. And it's only, and clearly this affects the public, because it's going to bring jobs to a halt. These are schools, these are government buildings, et cetera.
Now, when Arch moved for summary judgment, did you make this argument before the motion judge?
Arch never moved for summary judgment. In 5.5 years of litigation, this issue never came up. It was only, in fact, what they did on the...
The question is, did you argue this below?
I did not argue this below, and let me tell you why. And my fault. The reason I didn't argue it below is because, as I said, on the eve of trial, they still were of the position that they were responsible and liable. They even moved to sever so that we could wait until we find out what happens with Brait, and then they would be stepping in the shoes of Brait, which is what the bond requires. In their motion-directed verdict halfway through the trial, they specifically just argued on the actual language of this article in the contract. And that's what we got focused on. And so it never was brought up by any party. And again, I'll take responsibility for that, for not raising it at the time, but it is of such public interest, and it has been fully briefed, and it's likely to come up again, and it affects thousands, maybe even millions of construction workers in the Commonwealth of Massachusetts, public buildings, et cetera, that, I think I don't think we've lost that right by not waiving it in opposition to the directed verdict motion.
We'll have to leave it there, counsel. Your time is up.
Thank you very much.
Thank you very much.
Thank you.